be submitted.
Good job.
All right, and we'll proceed to hear argument in the next case on calendar for argument, which is 24-2545, United States of America versus Joshua Ian Selnick. And we will hear first from Mr. Torgoli. Did I pronounce that correctly?
You did, Your Honor. Thank you.
All right, great. You may proceed.
May it please the court, and I would like to cede 2 minutes for reserve. My name is Shaw Torgoli. I represent Joshua Ian Selnick. He was the defendant at trial and is the appellant before the court, who convicted after a jury trial, which included fundamentally 3 issues that I'm going to focus on today. I'm going to take them out of order because the first issue raised, the Crawford hearsay issue, has a tendency to meander and include some other things, but I think it'll make sense to the court why we do it this way. Judges, after Mr. Selnick testified during the defendant's case, the government recalled a hybrid witness, and the hybrid witness, Special Agent Cullen, Special Agent Forensic Examiner Cullen, he, to that point in trial, had already been introduced as an expert to the jury and testified as such. In his rebuttal, he presented to the jury 3 distinct areas of testimony which were undeniably expert in their nature, and in fact 2 were characterized by the government as experiments.
And as I understand the record, there was no objection at trial to his testimony on Daubert grounds or expertise grounds. Am I correct?
Before the trial judge, there was findings by the court, yes, and that is true.
Now, when he took the stand in rebuttal, you're now making an argument that the evidence should have been subjected to a Daubert standard or something like that.
Correct.
That was never raised below.
Well, at the end of his rebuttal testimony, that is when defense counsel objected. So it's our argument that it was preserved
Objected
then.
on Daubert grounds?
Well, the way and I'm glad the court asked that question. It's something that's come up in our briefing.
Because the answer is no.
The answer is kind of. Defense counsel, in his objection...
Is that enough for Daubert? Kind of?
Well, if I may get to that point, Your Honor, the point that defense counsel makes is that he was fully unprepared for these areas of testimony and required some sort of disclosure under Rule 16. Daubert, of course, refers to tendering experts as experts, and it connects very closely to Rule 16.
But that's a different argument than you're making on appeal. What you're saying is he shouldn't have been allowed to testify as an expert if he was in rebuttal, and you never raised that argument to the trial judge. And so you're asking us to reverse the trial judge on an argument you never made to him. We can do that, but it has to be plain error, doesn't
it? If the court settles that defense counsel did not preserve this, then yes, the court is right. But we would argue differently, Judge. At the end of the day, what the defense counsel did argue is that he needed some kind of curative relief by the court. And what he did is ask for disclosure discovery under Rule 16, and what the court...
But Rule 16 doesn't require disclosure of rebuttal experts in advance.
That's true, Judge. It does not. It doesn't require that. And so I'm not sure that his choice to call
the
it...
The objection that you seem to make does not seem to be well taken and doesn't seem to suggest that there should be some kind of a Daubert hearing.
Could the judge repeat the question?
I said it doesn't sound like the objection that was raised was well taken, nor that it would seem to suggest to the court that it should be conducting a Daubert hearing at that point.
Well, so here's the problem, Your Honor. The trial court did already review the qualifying expertise of the witness prior to trial. The issue is the expertise was as a forensic examiner with a couple weeks of training, but far more on-the-job training at the FBI. His expertise related to the forensic examination of computers, of hardware, of things of that nature. The three distinct areas of his rebuttal testimony pertain far more directly to BitTorrent and to the technology that allows peer-to-peer.
Did they? I mean, as I read his testimony, it was essentially your client took the stand and said, if this stuff is on my computer, if there are links to this stuff on my computer, because it's not on your computer with BitTorrent, they must have arrived through some inadvertence, either because X, Y, or Z. And as I understand the rebuttal testimony, it was the agent saying, well, I tried X, Y, or Z, and what he says didn't occur. And so it's rebutting the factual testimony or the testimony of your client. It's not expert testimony about BitTorrent. It's not expert testimony about other things. It's, I tried to replicate what he said, put this stuff on his computer, if you will. And when I did it, that's not what occurred. Isn't that what his testimony was?
I'm not sure I entirely agree with the characterization, Judge, because some of what he did could not be replicated by any person of average experience or education. These are technical things that the rebuttal witness did. And I need to point out to the court, he actually ran these experiments. They're literally called experiments by the government. These were run before the defendant testified, beforehand. And
so they were prepared for his testimony. I'm not sure the fact they were run beforehand makes any difference.
Well, I submit to you, Judge, that when an FBI forensic examiner is running experiments prior to a defense case, that is essentially an extension of the investigation, which should be subject to, if not Daubert, some sort of gatekeeping function by the district court. And at each of these tests, Judge, and I think it's an important distinction that these relate to BitTorrent and not simply relating to the area of testimony that was proffered during pretrial hearings. His first test, he claims he pulled torrent files into app data, which did not cause the torrent client, it did not cause it to be added to the torrent client. This was designed to explain away data transfer between devices, which is something that came up in the defendant's
testimony. And your client's testimony was it must have gotten inadvertently transferred between devices.
That's right, Judge.
And so he said, I tried to transfer between devices, and this didn't occur.
He says he did it before the defendant testified, Judge. That's correct. But this is not testimony presented during the government's case in chief.
It was in rebuttal.
Correct, Judge. The second test was this is the agent again, could not use the graphical user interface to select hidden folders. Instead, he had to physically type in a file path to make that happen. Again, this is a BitTorrent area of testimony. This is not about the hardware or even the software in a standard computer or something that would be within the framework of a forensic examiner's expertise. Lastly,
was there any doubt that the defense in part would consist of, I don't know how this stuff got on my computer?
I submit to you, Judge, that is a very predictable defense, and in fact, so predictable to the government. In the post-Miranda interview, occurred almost 5 years earlier, the defendant laid out in a 110-page interview exactly that defense, and it was the same defense at trial 5 years later. So this notion, and the AUSA argued it briefly, that we have no idea what the defendant's going to say is hogwash. It was it was so predictable, they predicted it. And they ran experiments.
Yeah, but I'm not sure why that matters. They don't know that he's going to take the stand. He may decide at trial not to. If he doesn't take the stand, maybe they don't want to put on this rebuttal evidence because otherwise the case seems unrebutted. So they're prepared for his testimony. I'm not sure there's a rule that says they have to run the experiments right after he testifies.
So, and Judge, here's the issue. If you're the defense attorney in this trial, you've had access to discovery, at least as the federal rules contemplate them, and these are expert experiments in the government's description conducted that the defense counsel has no access to, cannot review. It is not replicated before the jury. And ultimately, he is unable to do anything besides ask a few questions about why it wasn't preserved. He was not able to take those and share them with his own expert to have them evaluated. And I think this is why he settled on Rule 16 in his oral objection. I think that's why he got there.
Are you arguing that the government's preparation, anticipating what the defendant will offer as a defense, is somehow Brady?
I think it could be, Judge. And I'm not sure here if it is. We're not raising that argument. But when contemplating the weight of the evidence, the defense should have access to expert experiments that are conducted by the government using government resources for the purposes of establishing a defendant's guilt beyond a reasonable doubt. If it includes Brady, I would love to be able to make that argument today. I'm not in a position to do that.
I know you've got
Brady never includes inculpatory evidence.
No, that's correct, Judge.
And I've got limited time, and I'm interested in hearing your Crawford argument. And let me just set it up for you. These all seem to be machine-generated reports, and all they really do is, as I look at them, and some are hard to understand, say, yes, this file that was on his computer, this link, if you will, to BitTorrent. When I run it, it turns up child pornography. So tell me why that's hearsay.
So the software, Torrential Downfall, as the court is probably aware, is created in collaboration with law enforcement. It's controlled only by law enforcement. It's available only to law enforcement. As I understand it, it's only been validated by the FBI. So everything about the machine, if you will, is a government machine.
But the witness didn't testify about the machine, if you will. He just said, I used the machine and this is the reports that it produced. And you could cross-examine the witness. You could have asked him anything you wanted about the software. So I'm trying to figure out why the ultimate reports generated, which is all that was put in evidence, are themselves testimonial hearsay.
So, Judge, these logs are the chief evidence on the three distribution. The more serious counts of conviction here, that the logs are what show it in the government's estimate. And this software includes, pursues hashtag items that have already been in a different database that only the government controls, determined to be exploitative material. Apologies. And so in this particular case, Judge, we're kind of at a frontier where what is machine generated. I encourage the court to take a broader view, because if government created and controlled software can peer into people's computers and say, we found X on there, it's X because our database says so. And from there, we believe you distributed it because we entered your computer to download either bits or its entire, in this case, in its entirety. And here's the massive log that you can look at and cross-examine the witness, if you will. But in this case, the witness who initiated this is unavailable, which is part of the problem. At the end of the day, Judge, what is machine created here is really, it deserves a more nuanced view.
This isn't so much a Crawford argument as just a foundation argument. I know, and what you just articulated didn't seem to have any element of Crawford in it. It's all foundation.
Our argument, Judge, is that there are aspects of the creation process, how this log comes to be created and determined, that is testimonial, that cannot be effectively cross-examined just by plunking a log down in a courtroom and saying,
so on
have
that
at it.
argument, it has nothing to do with whether it was Daniels or Cullen.
We disagree, Judge. It was Daniels who initiated the creation of these logs, whose inputs and whose selective discretion is what led to the creation of the logs. Daniels was unavailable.
But I mean, given, that Agent Daniels untimely passed, why is there an abuse of discretion for the district court to permit someone to come in and say, I reran everything and, here are the results in the report and it all matches up?
Well, the trouble, Judge, is that no one really reran it in the traditional sense. The offenses that took place here were investigated at the behest of Agent Daniels, who conducted the underlying log creation on dates that linked up with the indictment in
If
2018.
Daniels had testified and testified exactly the same way the agent who testified at trial testified, would you have a hearsay objection?
Unlikely, Judge.
That's why I'm having difficulty figuring out why. Because the testimony at trial from the agent didn't describe what went into the creation of the software. So if Daniels wouldn't have been required to say that, why is the substituting agent required to say it?
By analogy, Judge, if the agent who initiated the creation of the logs using government's own software were available, the defense would be more effectively able to confront him and the decisions he made that went into the creation of the ultimate log. I apologize, Judge. I'm nearly out of my entire time here.
That's all right. I'll give you the 2 minutes because we asked you a number of questions. So, all right. So we'll hear now from Ms. Delord. Did I pronounce that correctly? Okay.
Good morning, Your Honors. May it please the Court. I am Carla Hodes Delord, representing the United States. I will begin where we just left off with the Confrontation Clause issue. There was no Confrontation Clause violation here. As the District Court correctly found, the torrent logs, which the defendant takes issue with, were machine generated.
So just so that I understand exactly what the record is, were the logs, the actual exhibits that were admitted, were they the ones that were the historical ones that corresponded to Agent Daniels as opposed to regenerated new logs? I assume they're the former.
Correct. It's not. It is. It wasn't specified whether these were the exact logs that came from Agent Daniels or Agent Cullen. Agent Daniels, the testimony was that Agent Daniels started the investigation. So yes, when you start the investigation, the logs are automatically generated. So yes, these would be the logs generated from when Agent Daniels started the investigation. That's correct. Agent Daniels, his part after that, after you started the investigation, was then he made the forensic image of the defendant's devices, the forensic copies. Agent Daniels passed away. Nothing else from Agent Daniels was presented or before the jury. Agent Cullen went through and he verified that the forensic imaging that Agent Daniels did was correct and an exact match. The past values matched.
How did explain to me the foundation for how he verified the forensic copy?
It's through a process using hash values, and hash values are equivalent to they're more exact than DNA, for instance. The odds of having an exact match, if there's any little piece that's off, they won't match up. So if you have this hash value match, that verifies, that says that these are identical copies. And so Agent Cullen went through and using his forensic examination and doing this hash value calculation determined there was a match, and it was that his copy he came up with was an identical replica of what Agent Daniels had done.
So he's comparing copies that he derives using the program with the copies that Agent Daniels derived.
Correct, yes. So he verified that it was an exact identical copy.
Okay,
correct.
So let's go back to the testimony about what the logs show. Mm-hmm. In other words, I understand that this is just a verification that the original mapping did produce these images. Let's assume Agent Daniels had testified and we didn't have to have the substitute witness. Describe for me, the government has this proprietary software, if you will, that allows them to look at the BitTorrent reference on a computer and then match it up to an image. How can they cross-examine you about whether that accurately produces the right image?
And again, that can also go to foundation authentication as well.
Yeah, and I'm not worried for the moment about the nature of the objection.
Correct.
I'm just trying to figure out how a defendant, when confronted with this testimony, gets the ability to cross-examine.
He could so we had Detective Ertley. Detective Ertley is a co-developer of the software. So he could cross-examine Detective Ertley on the software and being the co-developer and things of that nature about it. And then, which he did have that ability to do that. And the court, in doing this, the defendant had made a hearsay, foundation, and authentication objection, and the court went through after listening to Agent Erdely's testimony about the software and how it works and the results it produces, found that everything was machine generated. There was no hearsay. It was not testimonial. And then the court also found at trial that the government had sufficiently met the foundation and authentication for the program to come in. So that is how a defendant could challenge this in the future. And he had the opportunity to with Detective Erdely. So there is no confrontation clause violation here at issue.
Now, can you turn to the rebuttal testimony, if you will?
Yes.
And put aside plain error or preservation for a moment. I take it it's true that the government had run these tests, if you will, before the defendant took the stand?
The Agent Cullen testified that when he was in his hotel room the night before the defendant testified, he was trying to anticipate what the defendant's testimony would be the next day. So he, on his own, ran these experiments. At trial, the defense objected on disclosure grounds, did not raise a Daubert
And
hearing.
then the judge says it's rebuttal.
The judge found that it was impeachment testimony. So even if this court were to find that it went beyond impeachment testimony and it went to expert testimony, there's still no problem here. There's still no error. And the reason is because before trial, the government noticed Agent Cullen as an expert. It said he did the forensic examination of the defendant's devices. He had knowledge of various operating systems. He had knowledge of the dates, when dates were accessed and dates were modified on a computer. He was also familiar with the cleaning software. He testified to these things on direct examination.
So your position is, had they raised a Daubert objection, you could have established his expertise?
Absolutely. No one was disputing that he was an expert. No one disputed that he was an expert. And in fact, based on his testimony that he had during direct, the court was able to evaluate his testimony, the reliability and relevancy. And as the district court found, had the defendant not testified or had he testified differently, the Agent Cullen's rebuttal testimony may not have even been relevant and it may not have even been brought up to begin with. But because the defendant testified the way he did, that is why Agent Cullen was called as rebuttal to impeach that testimony, to say, defendant says if I run X, I get Y result, and Agent Cullen got up to rebut that and said, I did run X, I got Z result. But that was all within the realm of his expertise, everything he talked about on rebuttal. Whether it was impeachment or expert testimony, it was all within his expertise.
But you're not arguing that his rebuttal testimony was the testimony of a layperson, are you?
No, I would say, yeah.
It would have required expertise.
It would have, and which was clearly established, and no one objected to that. And if the court were to somehow find that there was error, it doesn't rise to the level of plain error, in that the defendant's substantial rights were not affected, in that the defendant got to cross-examine Agent Cullen 2 different times on his rebuttal testimony alone. And in addition, the amount of overwhelming evidence that was presented against the defendant in this case. If the court has no further questions on any of the issues, then we respectfully ask that you affirm his convictions and sentence.
All right. Thank you, counsel. We'll hear rebuttal now.
Judges, thank you for the additional 2 minutes. The court asked a question, well, how is it that one facing significant charges with due process on their side can cross-examine this software? And the answer the government presented was by cross-examining one of several people that helped develop the software. And so It's not hard to see, and the reason I encourage the court to take a more expansive view of what is machine generated is we're literally at a frontier where AI can start doing these things on its own. And matter of fact, Detective Erderly said that there are settings here that allow the software controlled only by the government. In fact, so controlled by the government, it's outside of our record, but the government does protect this proprietary software in this district and in others. If we're at a point now where the programmers of this software can simply say, as far as I know, it works, deal with it, it's going to make it incredibly hard to effectively cross-examine the results. It's not enough. There should be more in a situation like this where the chief evidence of distribution is created by government-controlled proprietary software. It's not available. The government mentioned that defense counsel got to cross-examine Agent Cullen not once, but twice, and that's true. If you read the record, there is almost nothing that he is able to cross-examine him about because despite using an FBI laptop, he did not save his results, he did not write reports, he did not take notes, and he could not replicate it in court. So how can defense counsel effectively represent his clients in a situation like that where the answer to every question is, you weren't in my hotel room? Sorry. That sort of argument should be really concerning to this panel. It's something that it should consider. I'm out of time. Judges, I would just close by asking for the reasons in our brief to reverse the conviction and the judgment against Mr. Selman.
All right. Thank you, counsel. And we thank counsel for both sides for their helpful arguments in this case. And the case just argued will be submitted.